David, you know, if this was a jury trial, I guess we just have a thumbs up or thumbs down, guilty or not guilty, right? But
that's right.
Here we have a judge's ruling, and you know, it's not brief, right? But the judge was able to go into detail on the rationale behind the ruling. What is your sort of, having heard it and read it, what's your takeaway from it?
The judge did a very deep dive on a core issue, which we see every day in courts. Who do I believe? So that's a central issue when you have diametrically opposed perspectives on an event. The judge really has the very difficult task of sorting out what evidence do I accept, what evidence do I not accept, and most importantly in a criminal case, what evidence might give me pause or reasonable doubt. And that's really where she focused the bulk of her analysis.
Were you surprised by the way things played out?
I'm not surprised by the verdict. It's a high burden of proof. The Crown had to prove lack of consent beyond a reasonable doubt, and the burden of proof is higher to absolute certainty than it is to a balance of probabilities. There were issues in the complainant's evidence, issues around her reliability and credibility, contradictions in her evidence at trial compared to other statements that she made previously. So I'm not surprised that this was a not guilty verdict for all 5 defendants.
It's important to remember that it is a criminal trial. That's why the bar is so high, right? London police, as we all know, closed the case back in 2019, right? And it was sort of put over there. A number of lawyers for the defendants made the case that, you know, they criticized even the laying of charges at all. Let's give a listen to a clip.
Every single feature of the evidence that Justice Caracia identified today as fatal flaws for the Crown was known to prosecutors and to police from 2018. Today's outcome was not just predictable, it was predicted.
Meanwhile, one of the lawyers for the accused, Alex Formanton, said the Crown forged ahead with, I'll read the quote, a hopeless prosecution. Hopeless prosecution. This one to you, David. I mean, what do you think? Should the Crown have gone ahead? Should they have laid charges?
Absolutely, yes. And here's the thing. You have very serious allegations, and you have a complainant who the Crown interviews, the police interview, has not been cross-examined. The defense lawyers have not done their job yet. And it's the duty of the Crown to put forward reasonable allegations, let a judge hear them, let the defense attack them, and let an impartial jurist make an ultimate decision. We all win if those cases play out in the public and an impartial adjudicator pronounces publicly on the outcome, rather than a prosecutor making a decision behind closed doors to go ahead or not go ahead with a decision that could dramatically affect the life of a person who identifies as a sexual violence survivor.
EM's lawyer also spoke. There was, you know, all the lawyers came out after the ruling today. EM's lawyer was one of them. And let's give a listen to that clip.
Her choice to testify came at a great personal cost. 9 days of testifying was more than she ever expected. Her treatment during cross-examination at times was insulting, unfair, mocking, and disrespectful.
So we got that. Meanwhile, we heard from the judge on the same issue, who, and I'll read another quote here. The time spent, particularly in the cross-examination of EM, was entirely appropriate. Lydia, to you. This gets to a thing I think a lot of people are wondering. How do you balance the well-being of the complainant, right, with the rights of the accused? What are your thoughts on that?
I think a skilled cross-examination of a complainant doesn't have to be abusive, it doesn't have to be mocking, and I don't think it was in this case. A lot is at stake for the defendants. Their liberty is at stake, their ability to have an income, their family relationships, all of these things are at stake for an accused person. It's a very serious matter, and the state is presumably, in this case, trying to take away the liberty of the defendants. So to balance that, I would argue that they were respectful to the complainant. They asked her hard questions. They did challenge her evidence, but we have an adversarial system, and we got an outcome which, in my view, was the right one.
We also heard from EM's lawyer that how the impact of being told you're not believed is resting with her. David, you've represented both sides in these kinds of circumstances, the complainants and the accused. I wonder about conversations you might have with a complainant ahead of such a process. Will this affect what you say to complainants? Because you don't know how it's going to play out.
It will solidify what I say and have been saying for years. I think Lydia is entirely correct that if you look within the parameters of the criminal justice system as it's currently constructed, it's difficult to criticize this outcome. The bigger problem is, can we actually do better with a range of alternatives? Why adversarialism in every case? If we can move outside of that and look to restorative options for some appropriate cases, then we can spare complainants the kind of trauma that this complainant endured during this and cross-examination. And I'm not criticizing the lawyers. They did their job according to the rules as they currently are. My point's a very different one. We have to have alternatives that approach these issues differently.
What are your thoughts on that, Lydia? I mean, I think that weirdly, it's gut-wrenching and life-upturning, that's a phrase, for both sides here, for the hockey players, for EM. Where are we at the end of all this? What do you think?
I don't think this is necessarily going to fundamentally change the way criminal trials are done, although I should say other cases where there was a lot of public scrutiny did lead to changes in the law, and I'm thinking in particular the Gomeshi case. But I don't think this is necessarily going to change the way the law is done. But I do think it's a testament to the fact that we have a system that works, that the burden is high for good reason, and that this is the process that we have. And if we really care about sexual assault and addressing sexual assault, we need to have good sexual assault laws, and that includes having a defense, because otherwise it would be meaningless. If we didn't have due process, if we didn't have a system where the Crown actually has to prove the case, then the law is meaningless.
Thank you, both of you. Very thoughtful. I appreciate your time. Thank you.